Visashlim. Visashlim. What a pretty song by Baruch Chait. How's everybody doing? Good Shabbos, good Yom Tov. We're almost into Shabbos, and it's going to be a 3-day Hag since we go into Shavuos Saturday night. So a reminder, we won't have class Saturday night since we're going into Shavuos, nor on Sunday, nor on Monday, because we come out too late on a weeknight. So after today's class, the next class will be on Tuesday at the regular time, 6 p.m. Pacific, and then we'll do a highlight show for these 3 days. It's great to be with you on a Friday. Let's light up the darkness. And my computer cut the feed, but the camera didn't. Awesome. Okay, who is with us on a Friday? John in Maine, Guy in Ohio, Jane in Southern California, Bella saying good Shabbos, Gordo in Scotland. It must be Friday. Great to see you. Bill in mid-Missouri, Miriam in Hayden, Colorado, Paul in the Great Northwest, Lucy in Minnesota, Bella in Florida, and I gotta reload. Wonder why it does that. The feed does not get cut. My computer says it's over, and I refresh, and it's not over. Facebook. It'll be great when we get the AT app going. That is proceeding slowly but surely. Yitzhak in Kansas City, Marjorie in Virginia, Lynn in North Texas. Welcome, everybody. We have a really interesting daf today. Let's get into it. We're opening a new chapter. This is chapter 10. We're going to pick it up on 87b. Not so near the end of 87, but it was a good place to break yesterday as we're opening chapter 10 today. So we're in Tractate 14, Yevamos, the laws of levirate marriage, Yibum. And in all these chapters, even when we took digressions, we were in some way exploring the laws of Yibum, when a man dies married and childless, leaving a widow and a brother. The brother has an obligation to step in and perform Yibum, levirate marriage, or if he and the widow don't want to marry each other, they can perform chalitza, the alternative commandment, the alternative mitzvah that releases them from the levirate bond. But one thing that's been an assumption in all of this is the reason we're talking about Yibum is because the husband died. What if it's not so certain that the husband died? What if there's a question? Was there a death or not? What if we assumed there was a death and it turned out there wasn't? Raises many, many difficulties. We're going to explore that here in chapter 10. And this first Mishna, you hear the first 6 paragraphs of it, and you're like, oh man, this seems so unfair. This seems terrible. This poor woman. And then the last 2 paragraphs totally flips over what we think we've been reading. Let's get into it. Mishnah number 1 of chapter 10 in Tractate Yevamos. With regard to a woman whose husband went overseas, and witnesses came and they said to her, your husband is dead, and she married another man on the basis of this testimony, and afterward her husband came back from out of the country. Now, what is she to do? She must leave both this man and that one, as they are both forbidden to her. And she requires a bill of divorce from both of them. And it makes sense when you just think the simple facts are she was married to a man. She assumed that he was dead and had good reason to assume. So she went and married another guy. And then the first guy comes back. So what did she actually do? She committed adultery with regard to the first husband, was with another man. She thought she was married. It was not a legitimate marriage since she was still married to the first guy. She had sex with him as part of her presumed second marriage. That's adultery. She now becomes prohibited to her first husband. That's why she can't go back to him even if he forgives her. The second husband was never a legitimate thing, and she's going to be penalized that she can't be with him because of the whole underlying policy of this. What are the sages really saying? even if there's good reason to assume that the first husband died, you gotta make crazy sure that he died before you go off and assume he was dead, start your life again, and marry another guy. That's one of the underlying policy assumptions here. Now, in the modern world, when we have such a much more global type of society, it's not that difficult to get information about somebody's whereabouts anywhere in the world. I mean, it certainly can be. People do go missing all the time. But we're much more, tethered to each other around the world than we were in ancient times. I mean, in ancient times, somebody gets on a ship. A few days later, it's like they dropped off the end of the world. Who knows if they're coming back? They could have been shipwrecked. The ship could have sunk. They could be imprisoned, enslaved. They could end up in who knows where, be gone for years, and never get any information back. It was a very, very sort of present problem to the ancients that somebody who traveled might never come back. Let's continue. So they're saying that if this woman, she relied on testimony that the first husband was dead, but then the first husband shows up after she remarries, they're going to make her divorce both of them. And furthermore, she has a claim to neither husband for payment of her ketubah, her marriage contract, nor the profits of her property used by either of them, nor sustenance, nor the worn clothes that she brought to the marriage. She has rights to these claims, neither against this man nor against that one, and she cannot collect these payments from either her first husband or her second husband. And if she took any of these items from this man or from that one, she must return them to him. And the offspring is a mamzer from this one and that one. Her child from the second husband is a definite mamzer. He's the product of adultery, since that second marriage was not legitimate since the first husband actually was alive. And she was never divorced from her husband. And the sages decreed that if she returned to her first husband, then a child born later from him is also a mamzer. Her original children with him, they're not mamzers. But if she remarried when she thought he was dead, and then she returns to him when he shows up again, and then they have another child, that child would be a mamzer according to this Mishna. And neither this man nor that man may become impure for her upon her death if they are priests, and neither this one nor that one is entitled to the rights that stem from the marriage bond, neither to her found articles, nor to her earnings, nor to the nullification of her vows. In other words, these marriages get dissolved. And if she was a regular Israelite woman, she is disqualified from marrying into the priesthood, as her intercourse with the second husband is considered an act of illicit sexual relations. That would render her a zona, a harlot, and that's why she becomes prohibited to marry a priest in the future. And the daughter of a Levite is disqualified from partaking of the first tithe, and the daughter of a priest is disqualified from partaking of teruma. And neither the heirs of this man nor the heirs of that one inherit her marriage contract as an obligation that they need to pay to her, as she is not considered married to either one of them. And this clause will be explained in our Gemara. Now, if they died childless, then the brothers of this one and the brothers of that one must perform chalitza with her, but they may not perform yibum. Rabbi Yosef disagrees with the first Tana and says that she does receive payment of her marriage contract, and the obligation of her marriage contract is upon the property of her first husband. Rabbi Elazar says the first husband is entitled to her found articles, to her earnings, and to the nullification of her vows. Since the second marriage was an error, the first husband does not forfeit his rights. Rabbi Shimon says an even more far-reaching ruling: her sexual relations or her chalitza with the brothers of the first husband exempts her rival wife, as it is considered a proper yibum or a proper chalitza. And certainly she does not require chalitza from the brother of the second husband. And if she returns to her first husband, then a child from him is not a mamzer. Now, those last opinions are minority opinions. So the general effect of the Mishnah so far is that if this woman relied on testimony that her husband who went overseas had died, and then she remarries, and then that husband shows up again, she is screwed. I mean, that's the bottom line. She just is in a terrible position. She's forced to divorce from both of them. She's not entitled to any sustenance, payment of the ketubah. Her children from the second husband would be rendered mamzers. I mean, it's just a terrible, terrible situation. But all these laws refer to a situation when she married with the permission of the court after hearing that her husband had died. But if she married without the consent of the court, then it is permitted for her to return to her first husband. And if she married by the permission of the court, she must leave both of them, and she is exempt from bringing the sin offering. What? If she employed a permission from a beis din, from a rabbinic court, in order to remarry, and then the first husband shows up, then all of these terrible penalties apply. But if she does not rely on the permission of a court in order to remarry, then all these penalties do not apply. What? How could this be? I mean, for sure, in a rabbinic law-based legal system, we would want that people rely on the rulings of the court. And why in the world would the rabbis penalize somebody that relies on the ruling of a court and rewards somebody that doesn't? But let's think about it a little deeper. And the Gemara will explain below what's really going on. Why did she need the permission of a court? Is every woman who is contemplating getting married a second time going to need to go to a court to get a permission from a court? Certainly not. Well, the woman's husband was missing. Is it because the woman's husband was missing that she must get permission from a court in order to remarry? No, she can remarry. You don't have to go to a court to get a permission. Why did she rely on a permission from a court? Because she didn't have two witnesses. That's what's really going on here. If she had two witnesses come to her and say, we saw that your husband died while he was overseas, and she remarried based on that, that's an entirely legitimate course of action, and all these penalties do not apply. She made a legitimate error if she remarries, and the guy then shows up, despite the testimony of the two witnesses that he was dead, then she's forgiven. Okay, the second marriage, no good. But everyone understands that an error was made, so the children of that marriage are not mamzers, and she returns to her first husband. End of story. Why did she need a permission from the court? Because there was only one witness, and maybe it was even only a hearsay witness. Now, in that situation, the rabbinic authorities, right, the whole rabbinic legal system was very lenient and said, we're not going to make you an agunah. We're not going to make you a woman who's stranded and can never get married again because we don't have the full testimony that we should have, meaning two witnesses. At least there was one witness who maybe didn't even see it but heard that your husband died, and lest you be stuck forever as a single woman who can never get remarried, we're going to let you remarry. We're going to give you that permission from the court. But you're taking a risk that one witness was insufficient testimony. And that's on the woman. She has to make that decision. So what they're really saying to her is, listen, exhaust every possibility before you proceed on the testimony of a single witness and remarry. Wait a good long time to make sure he's not going to show up. He wasn't shipwrecked and he could be rescued. He got sick. He had amnesia. He was lying, recuperating. He was working his way across China to get home to you. Wait a good long time Because if you're going to rely on the testimony of one witness, so for that you need a permission from the court, but you're taking on a risk. What risk? The risk of these penalties. If, however, she did not remarry by permission of the court, she must leave her husband. She must leave her second husband and is liable to bring an offering for mistakenly having relations with a man forbidden to her. Right? See, that's what happened. If she relies on two witnesses, so she's not relying on a permission and taking on that risk. She had every reason to believe under Torah law that the first husband was dead. She had two witnesses. Okay, it turned out that there was a mistake. She made a mistake. It was not on purpose. What is she liable to? To bring a sin offering. That's it. Right? Bringing a sin offering, we only do that when the temple is standing. When do we bring sin offerings? When we mistakenly commit a transgression. When we intentionally commit a transgression, we can make an atonement for that, but not by bringing a sin offering. The chatas, the sin offering, only applies when somebody committed a transgression mistakenly. That's what she did. So were the temple standing, she would be liable to bring a sin offering. And in this regard, the power of the court is greater, as she is exempt from bringing an offering if she relies on the permission from the court. But if that first husband shows up, the sin offering, the fact that she has to bring it, is the least of her concerns because of all those other penalties mentioned in the Mishnah. Right? So if the court instructed her to marry on the basis of inaccurate testimony and she went and ruined herself by engaging in licentious relations outside matrimony, she is liable to bring an offering as they permitted her only to marry and not to engage in licentious relations. That's the Mishnah. Now the Gemara. From the fact that the second half of the Mishnah teaches if she married without the consent of the court, she is permitted to return to her first husband. This indicates that she did so not by the consent of the court, but rather by witnesses, plural. I.e., as there are two witnesses, she does not require special permission from the court. Now, with this in mind, it may be inferred that the first half of the Mishnah, which speaks of one who acted with the consent of the court, is referring to a situation where there was only one witness. Apparently, one witness is deemed credible when he testifies about a husband's death, i.e., the court will permit a wife to marry on the basis of the testimony of a lone witness. Normally, matters that are brought before a beis din, before a rabbinic court, there can be no ruling made unless there are two witnesses. It's a special leniency that they would allow a woman to remarry based on the testimony of a single witness so that she not get stuck in that situation forever awaiting a husband who will never come back because he just went missing. But there are risks involved, as we've discussed. Now, is it true that there is only this one situation, the case of the missing husband, where the testimony of a single witness is believed? The Gemara will discuss that there's some possible other situations where we take the testimony of a single witness. And we're going to get into a discussion of testimony and what's required. And then there's going to be analogies made to sort of other situations which sound so mundane. Did a person eat a piece of forbidden food, unkosher food, forbidden fat, etc.? And then one witness came and said it was forbidden or it wasn't forbidden. But what we got to keep in mind is while they're making analogies in the cases of, prohibited or permitted foods, what's always on their mind is deriving that we get the right outcomes when we're going to permit or not permit a woman to remarry based on the testimony of a single witness in various types of situations, right? The stakes are very high when it's not really did you eat a morsel of prohibited food, but really by analogy we're thinking can this woman remarry or not, and what kind of risk is she undertaking when she does so. And we also learned in a Mishnah on page 122, they established that they would allow a woman to marry if her husband was reported dead by one witness based solely on what he learned from the mouth of another witness. In other words, hearsay testimony. They're even going to allow her to remarry when one witness comes forward. He doesn't say, I saw your husband dead, but I heard someone say your husband is dead. And you can start to see, all right, they're going to let her remarry. But, hearsay testimony is, challengeable for good reason, right? I mean, a lie could have been told, a mistake could have been made. We're quite attenuated in such testimony from the actual circumstances of the death. So we're going to allow her to remarry on hearsay testimony, and also the testimony of a woman who heard from another woman, and even the testimony of a woman who heard from a slave or from a maidservant. In traditional rabbinic law, they don't take the testimony, witness testimony from women is not considered to be at the same credibility level as from men. From slaves, from minors, even lower. I mean, these are just ancient laws. Apparently, one witness is deemed credible in this regard, as whenever hearsay testimony is accepted, the testimony of one witness is also valid. So the idea that we would accept hearsay testimony or single witness testimony or testimony from witnesses who would otherwise be disqualified is something that's seemingly unique to this situation, where they're creating a leniency in order to allow this woman with the missing husband to remarry. And we also learned in a Mishna, on Karatot 46b, that if one witness says to someone, "You ate forbidden fat," and the accused says, "I did not eat it," then the accused is exempt from bringing an offering. And the Gemara infers the reason he is exempt is that the individual in question said, "I did not eat it," which indicates that if he had been silent and failed to deny the accusation, then the lone witness is deemed credible. So apparently, one witness is deemed credible by Torah law with regard to certain issues. It's not only in the case of the missing husband. Now the Gemara asks, from where do we derive this? The Gemara answers, as it is taught in a Baraisa, that the verse states, "Or if his sin be known to him." Leviticus 4:23 and 28. Right? This is establishing the law of bringing sin offerings. When it becomes known to you that you committed a transgression, that's when you become liable to bring the sin offering, when the temple is standing and there are priests serving there to do the avodah and bring the offering for you. I mean, you bring it to them, but they bring it to the altar for you. And this indicates that he himself must be aware of his sin, and not if it was made known to him by others. In other words, one is not obligated to bring a sin offering due to the testimony of others, even if they testified that he had transgressed. I might have thought that he should be exempt, even though he does not contradict the witness's claim. Therefore, the verse states, "If his sin be known to him," which indicates that in any case, however he comes by this knowledge, he is liable. Once he realizes that he committed the sin, he becomes liable to it. But if he says, "No, I didn't do it," they say, "We saw you eat that forbidden fat." He says, "Well, you might think you saw that, but I didn't do it." This is not a case of criminal law. This bringing sin offerings is a person who's engaged in a process of atonement. If he doesn't believe that he committed the crime, how effective is his atonement going to be? Makes sense. And you should know, and the Gemara clarifies this law. What are the circumstances? If we say that two witnesses came and informed him, and he does not contradict them, why do I need a verse to teach this ruling? That if he doesn't contradict them, and they told him he did it, okay, he's liable to bring the sin offering. After all, the testimony of two witnesses is always accepted. Rather, is it not referring to one witness? And yet, if he does not contradict the sole witness, in that case, the witness is deemed credible. So one can learn from this that one witness is deemed credible with regard to Torah prohibitions. But the Gemara refutes this claim. And from where do you infer that the reason due to the fact that one witness is deemed credible? Perhaps the accused must bring an offering because he remains silent, as there is a principle that silence is considered like an admission. It's almost like he joins with the witness against himself. When the witness says, "You ate prohibited food," he doesn't object. It's like his silence corroborates what the single witness said about him. And you should know that this is the reason, as the latter clause of that same Baraisa teaches, that if two witnesses said to him, "You ate forbidden fat," and he says, "I did not eat it," well, he is exempt. Rabbi Meir obligates him to bring an offering. Rabbi Meir said that this is a kal v'chomer inference. If two witnesses can bring him to the severe penalty of death by testifying that he had committed a transgression for which one is liable to receive the death penalty, should they not also bring him to the more lenient obligation of an offering? If two witnesses say, this guy killed that other guy, the murder was committed, this guy did it, the two witnesses saw it, death penalty offense, the death penalty applies. If we're going to actually bring in capital punishment on the testimony of two witnesses, will we not also obligate this guy to bring a sin offering on the testimony of two witnesses? But this is not the law. If two witnesses said to him, you ate forbidden fat, if two witnesses testified that someone had committed a transgression for which he is liable to bring a sin offering, and he denies their claim, he is not obligated to bring a sin offering in accordance with the opinion of the rabbis. It's different than a death penalty offense, and I think the reason is it makes sense because is he going to engage in atonement, knowing that he did it, admitting that he did it, so then the atonement can be real? If he doesn't admit that he did it, what atonement has really happened? On the other hand, a death penalty offense is not, that is about creating justice. Somebody engaging in an atonement for violating a Torah prohibition against unkosher food, that's really on him to engage in that process. But removing a murderer from society, yeah, we don't really care whether he admits it or not. We want to be able to execute that guy so long as we are 100% sure that he's guilty, right? So the rabbis said to him, there is a difference between the two cases with regard to an offering. What is the law if he would choose to say, I was an intentional sinner? If he says, I ate the forbidden fat and I did it on purpose, then he's not liable to bring a sin offering, right? He chose to do it. He chose to commit that sin. And in that case, there's an atonement that he can make. He has to get square with the Lord, as it were. But the bringing a sin offering when the temple is standing is not part of that process. Sin offerings are only for mistaken transgressions. So since he has the power to render himself free of, exempt from bringing a sin offering by saying he did it intentionally, then that's why we're not going to obligate him to bring the sin offering. The court's not going to step in and do that. On the other hand, when it comes to committing murder, whether if he says I did it intentionally, that's not going to get him off the death penalty, clearly. I mean, the opposite argument might work. He could say I did it by mistake. I didn't mean to commit murder. That's definitely a different situation, and probably that would not be a death penalty offense if he could prove the elements. One who sins intentionally is not liable to bring an offering. Once the accused in the latter clause of the Baraisa can negate the testimony that would have rendered him liable to bring an offering, he can likewise deny the act itself. Whereas, if witnesses testify that he performed an action that incurs the death penalty, so his denial has no bearing on the case. And the Gemara clarifies in the first clause, and now we're on 88a, in the first clause of the Mishnah, what is the reason that when he remains silent, the rabbis obligate him to bring an offering based on the testimony of one witness? If we say it is because the witness is deemed credible, but there is the case of an ordinary pair of witnesses, where even though he contradicts their claim, they are deemed credible, and yet the rabbis exempt him from bringing an offering. If so, they would certainly not obligate him to bring an offering due to the testimony of a lone witness, right? If two witnesses can't obligate someone to bring a sin offering when he says, no, I didn't eat it, then certainly one witness isn't going to obligate him. Rather, is it not because he remained silent? It must be a case where he remained silent. He didn't deny that he ate it. And silence is considered like an admission. If this is the reason why he brings an offering, there is no proof from here that the testimony of one witness is accepted, right? We were looking to this area of law where the testimony of a single witness seems to create an obligation to bring a sin offering as perhaps a source that they could use to allow a woman to remarry based on the testimony of a single witness. But now it's shaky. That doesn't seem to be the area of law from which they can draw that conclusion. Rather, this is evidently based on logical reasoning. just as it is in the case of a piece of meat about which it is uncertain if it is forbidden fat and uncertain if it is permitted fat. Was it kosher or unkosher? We're not sure. And there is no way of clarifying which it is. And one witness comes and says, oh no, it is clear to me that that is permitted food. So then the law is that this witness is deemed credible. So here too, the testimony of a single witness can resolve the uncertainty, right? So this witness that's coming forward and saying, I saw the husband die, it's because when he went missing, we're not sure. Did he die? Did he not? Is he missing? Is he coming back? We don't know. Now a single witness is coming forward. It's not so much to say, this guy died. I mean, he's obviously not penalized for any, he's not punished. No, he's not on trial. No one is on trial. There's just uncertainty as to whether he died or not. And perhaps that's why we would accept the testimony of a single witness, because he's there to resolve uncertainty. So the Gemara raises a difficulty. Is it comparable? There, the presumption of a prohibition has not been established. We don't know if the food is permitted, prohibited, as there's no proof that the piece was ever forbidden, and one can therefore rely on the lone witness who permits it. Whereas here, the presumption of the prohibition with regard to a married woman is established, right? She cannot remarry. The last status that she was in was married, right? So in order to come and uproot her status as a married woman, you would think that we would need more than just someone resolving uncertainty. We would need someone to say, no, I saw that guy die. And really, why don't we require two witnesses from that, right? But it's not the same. Somebody who comes and says, that food that you ate, it was permitted, is different than uprooting her status as a married woman. As there is no, and here the presumption of the prohibition with regard to a married woman is established. And there is a principle that nothing involving those with whom relations are forbidden can be determined by fewer than two witnesses, right? Did a woman have an adulterous affair, and that her subsequent child, which seemed to be born within a marriage, was actually the child of the affair? We're not going to make that kind of a statement with less than two witnesses, right? Anything about forbidden unions, creating a mamzer, was it incest, was it a death penalty, adultery case, etc. All of that absolutely 100% requires two witnesses. And are we not saying that this woman who's prohibited to all other men because she's married, and now we're going to permit her to a second husband, that's not going to require two witnesses? It does require two witnesses, but we have this special exception that the court could permit her as long as she undertakes that risk. So, in fact, this is comparable only to a case involving a piece of meat that is definitely forbidden fat, and a witness comes and says, it is clear to me it is permitted fat. And the law is that he is not deemed credible, right? The presumption was, no, the thing that he ate, we all agree, is prohibited. But then a witness comes forward and says, no, you're all wrong. That was permitted meat, and he's not liable to bring a sin offering. In that case, we don't accept the testimony of a single witness. So the Gemara refutes this claim. Is it comparable? There, when it is established as forbidden fat, even if 100 witnesses come, they are not deemed credible. Here, since if two witnesses come and say that the husband is dead, they would be deemed credible, and then she's 100% permitted to remarry. So let us also deem one witness credible. This is just as it is in the case of untithed produce, i.e. produce from which neither teruma nor tithe has been separated, consecrated property, and the laws of certain kinds of vows called Konamut, an alternative term for offerings, korbanot, used in vows creating prohibitions. Such vows are called by the generic term Konamut. And the Gemara asks, with regard to this case of untithed produce, what are the circumstances? If it is his, and he testifies that teruma and tithes have been separated from it, so he should be deemed credible because it is within his power to prepare the produce for consumption by separating tithes whenever he wishes. Rather, you must say that he testifies with regard to untithed produce of another. But if so, what does the anonymous sage who cited this example hold in this case? The Gemara explains. If he holds that one who separates tithes from his produce for another person does not require the owner's knowledge, and he can prepare his friend's produce for consumption whenever he chooses, well, in this case, too, his testimony is deemed credible because it was in his power to do it. In other words, somebody comes along and says, oh, you ate from that produce? That was untied produce. You can't eat that. That's a real transgression. You have to bring a sin offering for making that mistake. And by the way, replace what you ate plus the penalty of a fifth. But then someone else comes along and says, what are you talking about? That was tithed produce. This guy didn't make a mistake. He's fine. Now, that's one witness versus one witness. Maybe even there were two witnesses that say, no, that was untithed produce. Then one comes along and says, no, it was tithed. Well, if the one who says that it's tithed is saying it's tithed because he himself tithed it, we believe him. But if he's coming along and saying it was tithed because some other guy tithed it, we're not going to believe him. For that, we need two witnesses. Similar to the case of the missing husband. And if he holds that the owner's knowledge is required before someone else can separate the gifts, now we're getting a little bit into the weeds on who can tithe produce. Can you only tithe your own produce? If you're going to tithe your neighbor's produce, must your neighbor have awareness that you're doing it for him in order to be a proper tithing? We're going to skip that discussion. Then we get into the laws of Konamut, which is a korban, right, is an offering. A korban is like you come near and you bring an offering. So that's a generic term for offerings that are brought when the temple is standing. A korban singular, korbanos or korbanot plural. Konam or konamot is where you create the same relationship to some produce or to an animal as if you had made it a korban. But really what you're doing is taking a vow that you won't touch it, right? So if you say, I consecrate this lamb to be a shalom, right, a peace offering that I'm going to bring in the temple. I'm going to take it with me when I go to Jerusalem for Shavuos. So now that's a consecrated animal. I can't benefit from it in any way. I certainly can't eat it. I can't sell it. I can't work it. The only thing I can do with it is bring it with me to Jerusalem and hand it over to the priest at the temple so that it can be an offering. It's a peace offering, so I'll be able to eat part of it then. But otherwise, I can't use it for anything else. If you take a vow and say, this lamb is going to be like a korban, that's called a konam. Right? It's a type of vow, and we'll get this into the laws of vows later. But the importance of it is you don't have to bring it to the temple, but you can't sell it, you can't eat it, you can't benefit from it. It's like, it's going to be somebody else's, or it's lost or left to graze. You're just not going to be able to relate to it in any other way than if it were a korban. That's another area of law, but whether something acquired that status or not, is that one witness or two? That's a discussion we're just skipping for a moment. Rabbi Zera said, due to the stringency that you were stringent with her, the woman who married on the basis of a single witness, at the end, if it turns out that the testimony was incorrect and the husband is still alive, the law is very severe with her. Right? So that's when she relies on the permission from the court to remarry based on a single witness. She's taking a risk, and if the first husband shows up, she's in a terrible spot, okay? And she loses out in all regards. Because of that, you are lenient with her at the beginning by accepting the testimony of a single witness to enable the woman to marry. And the Gemara suggests, if so, let us not be stringent at the end and not be lenient at the beginning. So this is an argument to say, well, since the penalties are going to be so severe for her, if she undertakes this risk, why should we be lenient? Let us just say, you know what? It's bringing in too many problems. Children could suffer because of this and be deemed mamzers through no fault of their own. They're going to be tarnished with that terrible label where they can't marry any other Jew for all of their lives because the mother made this error that we enabled her to make as a rabbinic court. Let's not do it. Let's just say, okay, it's really tough luck that your husband went missing, but unless you can produce two witnesses that he died while he was abroad, you can't remarry. That avoids all these harsh outcomes for her. But for how many years is she going to be in that terrible position? Is she going to just lose her whole youth? Is she going to lose the possibility of having children? Maybe the first husband went away, they never had kids. He's gone. She's a woman in the prime of life. She should be able to get on with her life. She should be able to remarry. That's why they create this lenient structure that she can rely on one witness with permission of the court. The Gemara answers, due to the case of the deserted wife, the sages were lenient with her, so she wouldn't be in that position. Since it is not always easy to find two witnesses to attest to a husband's death, especially in war or in the old days when there were sailing ships, there could be a storm, the ship is lost, all hands die, all souls aboard are gone. Who's going to come and testify that they saw this man die? We have to be able to create a situation where she can remarry. There's some kind of, that's interesting because there's not even a single witness to come back from that if there's no survivors of the sunken ship. I wonder, we'll probably get to that at some point, would it be enough to say that, witnesses saw the man get on the ship and then the ship never came back? Can she remarry, or is she going to be in that terrible position? If somebody saw, some driftwood with the name of the ship on it like you would see in a movie, is that enough? We don't know yet. Now, the Mishnah teaches that if she was informed that her husband was dead and she married another man and her husband later returned, so she must leave this one and that one, right? So this is when she relied on the testimony of the court, on the permission of the court to accept the testimony of one witness. So Rav said, they taught this law only if she married by virtue of the testimony of one witness. But if she married on the basis of the testimony of two witnesses, she does not have to leave the second husband. So they laughed at him in the West, meaning in Eretz Yisrael, the rabbinic and Jewish community in the land of Israel, which had actually fewer sages in it in this later period than the Babylonian Jewish community, which was really more the seat of Jewish learning because they were free of persecution from the Romans. So they laughed at him in the West. So even though there's a smaller community, in some senses, the teachings of the community in Eretz Yisrael were deemed more pure, right, less adulterated, because those sages were still living and learning where the sage learning originally began in the Holy Land. So they laughed at him in Eretz Yisrael. The man, meaning the first husband, has come and stands before us, and you say she does not have to leave her second husband? Okay, we're not going to penalize her. We're not going to render her children mamzers. It's just an error. Okay. So, but Rav is saying, so what we said before as the outcome of the Mishnah was, okay, she had two witnesses, so all these penalties do not apply. The husband comes back. What's she going to do? Maybe the guy was missing for 10 years and she's been married to her second husband for a long time, set up a home with him, she's got kids with him. Very tough situation. Who's she going to end up with? Does she go back to the first husband who was missing all those years? Does she stay with the second husband? The Mishnah assumes she's going to go back to the first husband because that second marriage was the error. She brings a sin offering because of having cohabited with that second husband who's not really her husband since the first marriage was never ended. But we assume she's going back to that guy. But what if she says, listen, I loved you when we were young, but you've been gone for 10 years. My whole life is with this guy now. Rav says she can stay with the second husband. That's what the sages in Eretz Yisrael are laughing at. What are you talking about? She could stay with the second husband. Her marriage was never ended to the first husband, and here he is. How can you say she doesn't have to go back to him? So the Gemara explains, no. It is necessary in a situation when we do not know the man who comes before us claiming to be the first husband. Now we're not going to make her go back to him because maybe this guy who claims to be the first husband isn't. Right? There are movies like that. So the Gemara asks, if we do not know him, well, then even if she married by one witness, why should she leave? The testimony of the witness who says the husband is dead should be accepted if some guy is standing here and we don't recognize him and she doesn't recognize him. She's not sure that that's her first husband. And the Gemara answers, no, it is necessary for a case when two others came and said, we were with him from when he left until now, And it is you who do not recognize him, as his appearance has changed over the course of time, but this is him. So this is as it is written, Genesis 42:8, and Joseph recognized his brothers, but they did not recognize him. Right? Remember the story of Joseph? The brothers sold him into slavery. He wasn't dead as far as they knew, but the last they saw him, he was this teenage boy, right? Arrogant teenage boy dressed in that coat they took away from him. Now they stand before the second most powerful man in the world, the grand vizier of Egypt, and they do not recognize their own brother. You know, he's dressed in Egyptian, like an Egyptian, talks like an Egyptian, etc., but they don't recognize him. Well, what if that happens in the case with this woman's first husband? And Rav Chisda said that this verse teaches that Joseph left his brothers without a full beard and he came with a full beard, which is why they failed to recognize him. And this shows that one's appearance can change so much over time that even his own family members are unable to identify him. The Gemara asks, even in this case, ultimately, they are 2 against 2. Initially, 2 witnesses testified that the man was dead, and now another pair arrives saying he is alive. Why should the testimony of the witnesses who say he is dead be accepted, allowing her to remain with the second husband, while other witnesses claim that he is still alive? Now we're in 88b, and this is an uncertain case. And as this is an uncertain case, one who has intercourse with her stands obligated to bring, I think it's the asham, right? Is obligated to bring an uncertain guilt offering, right? So there's a type of offering that you can bring when it's just unknowable if you committed the transgression or not. You might have done it, you might not. It can't really be determined, so you bring the offering to sort of cover that situation. Now, since before she remarried, some witnesses say she is a married woman, while others now claim that she's a widow. So her relations with her second husband involve a possible prohibition that entails karas, death at the hands of the heavenly court, and whoever mistakenly performs an action of this kind is liable to bring the uncertain guilt offering. If so, this second husband must certainly divorce her. So Rav Sheshes said, we are dealing with a case where that woman married one of her witnesses, who testified that her husband had died. Since the witness himself has no doubt as to the truth, he is not liable to bring an uncertain guilt offering. He's sure he was one of the original witnesses. We assume he wasn't lying in order to marry her. The Gemara asks, even so, she herself stands obligated to bring the uncertain guilt offering as she has no personal knowledge of the matter and she relied on the witness. So the Gemara answers, it is referring to a case where she says, it is clear to me, for whatever reason, she is certain that this is not her husband and that her husband is dead, and therefore she too is not liable to bring the uncertain guilt offering when this guy shows up, says it's her husband. She's like, you're not my husband. I know my husband. You're not him. So the Gemara asks, if so, what is the purpose of stating this? And that is, if Rav is referring only to this particular case, he has not taught anything new. As even Rabbi Menachem, the son of Rabbi Yosef, stated his opinion only with regard to a case where witnesses came and afterward she married. But in the case where she married and afterward witnesses came, he did not state the law with regard to this case. So, to what ruling is the Gemara referring? As it is taught in the Baraisa, if 2 witnesses say that the husband is dead, and 2 say he is not dead, or 2 say that this woman was divorced and 2 say she was not divorced, this woman may not marry. And if she married regardless, she need not leave her new husband, as there is no uncontroverted testimony that she is forbidden to him. Right? So when we have a case where we're relying on 2 witnesses, but there are 2 pairs of witnesses contradicting each other, then what? Right? So in that case, we just have not established what the truth is. We always rely on 2 witnesses, but now we have 2 pairs of witnesses contradicting each other, so we just don't know what the truth is. In that situation, we would not permit her to marry based on this unestablished truth, but if she did marry, then we don't force her to divorce based on this unestablished truth. And so when the witnesses who contradict the first pair by claiming she is still married came and afterwards she married, despite their testimony. However, if she married and afterward the second pair of witnesses came, this woman need not leave her husband. So the Gemara answers, when Rav spoke to, he was referring to a case when the second pair of witnesses came and testified that this is her husband, and afterwards she married. Rav claims that even in that case, she need not leave her second husband. His ruling serves to exclude the opinion of Rabbi Menachem, the son of Rabbi Yosef, in favor of that first Tana. And some say that Rav's teaching should be understood like this. The reason is that she married and afterward witnesses came. However, if the witnesses came and after she married, like what was the sequence? Did the witnesses come and say, your husband died and then she married? Or rather, the witnesses came and said, actually, your husband is alive and then she married anyway? Or the witnesses came after she had remarried based on the first set of witnesses, etc. It's going to change the outcome. And that's about as much time as we have for it today. I want to take some questions, which I imagine there'll be a few, on this very colorful topic. So reminder, we're going into Shabbos and then Shavuos, so no class Saturday night, nor Sunday, nor Monday. And we're going to resume on Tuesday at the regular time, 6 p.m. Pacific. And then we'll do a highlights of these pages that we missed during the 3-day Chag. Okay. Questions on Yevamos 88. Come on. Okay. Regarding the dead husband reappearing, Tom, she gets punished, but not her second husband. Well, I think the second husband does get punished, right? Because in the sense that they have to break up. They're not permitted to be together. So just to clarify, so we're in the situation where she relied on a single witness that her first husband had died. So she had to get a special permission from the court in order to remarry, but she undertook the risk, according to our Mishna, that if the first husband showed up, all these penalties were going to apply. So in that situation, so she's forced to be divorced, right, from both the first and the second husband. So in terms of the second husband, he's penalized in that he loses his wife. And if they had children together, he also suffers from the fact that the children are rendered mamzers. But I think what you're asking is, but what about the sin offering? And I think the answer is yes. I think he's liable to bring the sin offering too. Although, for what? Right? He didn't commit adultery. She did. She was still married. He presumably, well, first of all, a man can have multiple wives under ancient law. So he's not guilty of committing, well, but he is. He didn't commit adultery vis-a-vis his other, he doesn't, if he had some other wife. But right, he is a participant in adultery. So yes, I think he did it by mistake. So I think he would be liable to bring a sin offering as well. I think they just didn't detail that, but I think you're right. And I think, Tom, you must have asked that question. Why is it her fault? Why shouldn't the court take on the risk? Why shouldn't the court take on the risk? Because they're creating a leniency for her, but they don't want her to do this lightly, right? So even though they're going to create the possibility for her to get on with her life, they want her to wait. Now, you might say, well, but why don't they define some kind of acceptable, time limit? Like if she waited, 5 years or 10 years or whatever the number is, and there was only the single witness, and the court gives her the permission, didn't she do as much as we could possibly expect her to do? And in that case, they're not going to penalize her if the first husband shows up? You might think, but that's not what they did. Bell, I wonder if the Beis Din at that time required a jurisdictional basis, as they do now. So perhaps this was based on a hypothetical. I mean, for sure we've been talking in hypotheticals, right? So far, none of this has been based on, and there was an incident in which, where there was an actual true story, and they're just defining in a hypothetical case. But, as opposed to some of those cases where, what if a man ate, this huge amount of food at exactly the moment that evening turned into day, where it's necessarily hypothetical. Here it seems like, this could definitely happen, right? Especially in the ancient world where communication was so difficult, where it was so dangerous to travel. So I'm not sure what you're asking about the jurisdictional issue. I think that's really interesting. Will any beis din do? Or do you need like a sort of level of court? Do you need a geographic jurisdiction for this to work? Maybe we'll encounter answers to that as we move forward in this stuff. In this Gemara, in this tractate. Okay, Bill, here's a thought that I just had. Supposing she remarries on the testimony of one witness, and then some years later, another 2 witnesses come to testify that her husband did die abroad at a later date after her remarriage. In this case, does she need to make any kind of offering? For that matter, can she stay married? That he died after her remarriage. That's just, you almost wish those witnesses had not come. Because it's so like, she gains nothing. Like the man is not back, he actually is dead, but he died at the wrong time. Why'd you have to say anything at all? But it seems like if he died after she remarried and they could conclusively establish that, because I bet what would happen then is the sages would be like, how can you be so sure that he died before she remarried? That he died after she remarried. Because if he died before she remarried, then we're all good. She's in good shape. She stays in that second marriage. So that they would have wiggle room where they could try to establish that there's no certainty, and then she'd be good. You just made me think. Oh, because what there also is like, what if the guy was abroad, at a certain point he decided he wasn't coming back, and he put a get in the mail, right? He sent her a bill of divorce. So first of all, she's not divorced until she receives it, I think. It has to come into her domain. But again, the fact that he issued that bill of divorce and that it was witnessed, and perhaps it, just through some unforeseen circumstance, the agent who was bringing it, he got killed. Perhaps that would create some wiggle room. I think we're going to be examining that in later pages. So this is just a really interesting body of law with, extreme real world implications. We're definitely not just in the realm of the hypothetical here, that just affects lives so much, right? And so I look forward to resuming our learning with you, my friends, when we get back from Shavuos on Tuesday. Have a beautiful Shabbos and a beautiful holiday. And remember that we're celebrating the greatest day in human history, when God appeared God's self to millions of people at Mount Sinai and told us what God's will is for the human race. All the best, and have